Welcome back to the Senior Hour. I'm Barbara Cochran with my co-host, Dr. Jean Dorio, on your hometown station, AM 1220 KHTS. And our guest now is Randall Kaiden, who is an elder law attorney, and you are from the Kaiden Elder Law Group, PC. Your life,
yes.
Your legacy, your way.
That's right. It's
Good
our
to see
motto.
you.
It's
Good to
see
see you.
you guys as well.
Yes. Now, you have different questions here than what we were given by you.
Well, I think that might have been the previous month. I'm not sure, but what I wanted to focus on today is complacency. A lot of people do their estate planning, and they kind of think it's a one and done, and that they don't ever have to revisit it again. And I created a couple of points here, one to do with healthcare directives, another to do with the financial power of attorney, and the third to do with the estate planning itself. And I wanted to explain to people within each of those documents, why is it so critically important to update it? Mm-hmm. And I think context is really important, because a lot of people, they take it in a vacuum. They go and do their estate planning, for example, with the healthcare directive. Why don't we start with the healthcare directive? Mm-hmm. People will do their healthcare directive, and they put it in a drawer somewhere, and they never look at it again. That's right. And they could have done it 20 years ago, and that's what they were trying to predict for today. And what we're seeing, both with healthcare directives and financial powers of attorney, is that they're not being honored as much as we would like them to be honored. And it's important to understand how this law formed in the first place. Under common law, and for a very long time, it's been an established notion that we all have the ability and should be able to decide what we want done with our own body. Mm-hmm. But of course, when you can't make that decision, that's when you need to have some kind of agent or proxy there that, in theory, is able to help you make that decision. And there's some really interesting things here, because I get clients who ask me, what if I'm traveling in another state? Is this going to work? And I say to them, well, even before you worry about that, the bigger question is it going to work in California? And that's a little surprising to people. So there was a study actually done by Susan Shapiro in 2011, and there were some very...
Susan Shapiro.
Yeah, she works for the ABA, and she's an attorney, but also a statistician, and it's a common name, so you're probably thinking of somebody else. But
she is, because we have a Susan Shapiro here in Santa Clarita.
Okay.
She's very active and outgoing with the things she does.
Okay.
So we'll just think that she's done this.
Okay, we'll think that she's done this. We'll give her the credit.
It wouldn't be surprising to us.
So this was really interesting, because she did a study of 400 people that were in the ICU, and she wanted to find out whether or not their decisions were being honored, their end-of-life decisions. And what she found was startling. First of all, she found that 3 to 4% of people, only 3 to 4% of people were able to engage in their healthcare decision-making in the ICU. Another thing that she found was that 78% of the people that went in just deferred to the doctor, whether they had a healthcare directive or not. And about 50% of the people, what she realized was they may have named an agent under their healthcare power of attorney, but when it came down to it, they didn't want that agent making the decision. They wanted the doctor in conjunction with, let's say, a child, or usually it's the daughter or the female, the wife, that they want them to make the decision with. Mm-hmm. So in other words, what I'm saying is that people, what they think they've decided and what they've outlined in their healthcare directive, the studies have shown that they're not really being followed. And so that's kind of an amazing realization.
But it's not being followed because when they made the original decisions, circumstances have made it so that now they have a different opinion and direction they want to go.
Well, there's lots of reasons for it. That's definitely one of them. So, when we're talking about healthcare decision making, the first thing that we're always trying to do is apply the substituted judgment standard. In other words, we want to look and see what the senior wanted to do in this situation. And if we can answer that question, then we are going to implement what it is that the senior wanted to do. The trouble is that there's literally thousands of different possibilities that can arise. So there's this question between law and medicine and technology and humanity, and this is an ongoing conversation that really never ends because the law is behind the medicine and technology. And so things will arise and people haven't bothered to have conversations with their healthcare directive, their agents. They haven't had the conversation with their doctors. And so, in other words...
And sometimes with their significant others.
Their significant others. That's
they may think that way, and as you get older, your mind has a tendency to slip.
Right.
Believe me, I know.
Yeah.
And you think, gee, I did tell her that. I did tell them that.
Yeah, it's an amazing thing.
You've got a little bit of a situation on your hands.
So part of it is subjective, part of it is objective, and really what people ought to be doing is after they create the healthcare directive, first of all, they want to revisit it, don't let it go 20 years, maybe 3 to 5 years maximum, especially as we get older. The other thing is that we want to have conversations with our agents, and we want to involve the family and let them know what our wishes are to the best extent that we can. And then I advise all of my clients that are above the age of 70 to take that directive over to their doctor and execute a POLST, which is the doctor's order for the physician's order for life-sustaining treatment. And when you have the combination of elements put together and it's current, you're far more likely to have the outcome occur that you would have wanted to occur. And what we're seeing more and more now, too, is that people might want certain things not done, which that's sort of the traditional way of looking at healthcare directives, like the pull the plug kind of line of thinking. But now we also have the notion of what's called medical futility. And a lot of times families want a certain medical procedure done, and the doctors or the hospital might say, well, it's futile. It's not going to really help the person. And so there's really a lot to this, and it's very, very important not to sit on your hands and to follow up on this. And we just had the End of Life's Option Act enacted this year in California. So we do have a means, by the way, for people to end their life. And it's a very morbid subject, but it's kind of interesting to look at the history, because the history of the law really was born out of the last 30 or 40 years. First, people could be taken off of vents, and then the feeding tubes. Constitutionally, this was held to be something that somebody could allow if originally it was if they were close to death. And most of the end-of-life option acts, there's about 5 states now that allow it. We're under that same kind of thinking. If people are close to the end of life, then we're going to allow them to administer if the doctor signs off on it. There's a lot of hurdles to go through, but if the doctor signs off on it, and they can do that. So I could go on and on here, but I know we only have a limited amount of time, and so I just wanted to highlight that one point about the healthcare directive. Similarly, with the financial power of attorney, you have a lot of people out there who have created an estate plan, and they have a financial power of attorney for estate planning purposes that allows their agent to step into their shoes to do things for their benefit. And that completely makes sense. That's exactly what we do want to happen. Unfortunately, it doesn't allow the agent to do things that maybe traditionally are considered not for their benefit. In other words, divesting the person of assets in order to create things like an asset protection trust so that they can try to make their assets last a longer period of time with other government benefits that might be available to them. So I get clients that come in, it's usually the kids, and they say, Mom, she's in a board and care or skilled nursing, and she doesn't have dementia, but she did this wonderful estate plan, and I look at the estate plan and I say, yeah, that is a great estate plan. Too bad you can't do anything with it. I have to tell you, your mom, if she lives long enough, she's going to go bankrupt, and then you guys, I don't know what the kids are, they're going to kick in money to help pay for her. It's a big problem. And if you don't have updated powers of attorney, you're running into these kinds of issues. In addition to coming full circle here, the hospitals, doctors, and banks, more and more so, banks are not accepting these powers of attorney. It's important to go to the bank and make sure that they accept it. It's important to use also the power of attorney that they have at the bank and have that parallel what you've already done and the other power of attorney. So again, I'm coming back to this is a living, breathing thing, your estate plan. Now, when we talk about the estate plan in general, of course, there are things that people are pretty obvious to people why they would change their estate plan. Maybe there's been a death in the family, a divorce, a marriage, a birth, changing who you want to be in control, changing who you want to be have your assets. But in addition to that, there's a lot of legal changes. We had the DRA in 2006. We had ATRA in 2012. And this summer, we had what's called SB 833. These changed the rules on trust. So right now, we have a lot of married couples, for example, who are walking around with what's known as AB or ABC trust. They split apart when the person, the first spouse passes away, which causes a lot more administration, which causes a lot more accounting fees. Every year you got to file a tax return, you got to get a tax ID number, you actually have to split up assets and put them in those subtrusts. Totally unnecessary now that we have close to an $11 million exemption for a married couple. Before, people worried about having to pay transfer taxes, estate and gift taxes. Nowadays, 99.9% of society, they have less than $11 million. So they're not worried about that. So I believe, everything else being equal, in KISS theory, keep it simple. And let's have a simple estate plan so that when the first spouse passes away, the second spouse can just continue on and not have to deal with all this administration and costs for attorneys and accountants. And they can live in the life that they want without all these restrictions. Now, that's not always going to be the case, but definitely there's a lot of estate plans that people are sitting on that they could be updated and achieve a much better result. In addition to that, in our estate plans, we have lots of things that didn't used to be available in estate plans. For example, the ability to take out reverse mortgages or conduit provisions so that we can have retirement plans flowing through the trust without actually having them be subject to the 5-year rule where you have to take all the money out within 5 years and be taxed on it. The list kind of goes on. And then I also was highlighting personal care contracts. I actually have an article coming out in the Santa Clarita magazine this month, or in December rather, about personal care contracts. And I see this issue more and more where there's one child, it's usually the daughter, who has given up certain things to maybe a job or lifestyle to take care of mom or dad. And really, if there's a personal contract where they're actually compensated for this, then it tends to make the whole family feel better. The person actually is getting something to help them to do that, and it, in addition, has really great positive effects for Medi-Cal planning and veterans pension benefit planning because it can be counted as a medical expense, which allows us to get more benefits from these programs.
Well, wait a minute. You said Medi-Cal planning?
That's right. That's right. So,
well, wait a minute. I thought, what is Medi-Cal?
Medi-Cal is the California version of Medicaid, and that's really what is the safety net that when people go into long-term care, skilled care, it's going to pay for them if they either run out of money or they've engaged in advanced planning. And that's the one that's the most expensive. It tends to cost around $10,000 a month. But I think I told the story the last time of how I had a client last year who was getting care and is getting care at $1,130 a day. So you can really see how this can become so expensive.
Whoa.
And anything that we can do to alleviate the tension and the stress here, the better off the family is going to be. And so, again, I'm just trying to highlight just a very few of the documents that we don't want to sit on our hands. We want to revisit it every few years to make sure that we have the most current and up-to-date laws in the forms that where our wishes are being carried out in the way that we want. 10 years ago, 20 years ago, somebody might have had a heart condition in their 60s 20 years ago, and now they're in their 80s, and they have a completely different medical profile, and they want different things outlined in their healthcare directive. Again, the same thing with the financial power of attorney, the power to create irrevocable trust, to divest you of assets, the power in your trust itself, a living trust, to avoid a Medi-Cal recovery claim, to be able to get the benefits, the tax benefits, the benefits of being able to have a reverse mortgage if you were in that position. The list really goes on and on.
So not everybody qualifies for Medi-Cal. So you mentioned the term irrevocable trust. Is there a tie between Medi-Cal, since people don't qualify, they have too many assets, and irrevocable trust?
Absolutely. So we as elder law attorneys, or I should say elder care law attorneys, all the time, every week, we're creating asset protection trusts. So a person might have, let's just say their home, maybe it's worth $500,000, and they've maybe got a retirement plan and a couple $100,000 extra in investments, and it might sound like a lot, but in the world of long-term care, that's not a lot of money.
That's nothing.
And it's nothing, right? So what we do is, from a state law perspective, we're taking those assets, or the majority of them, and we're putting them in an asset protection trust that, in a circuitous manner, benefits the senior for the rest of their life, and then only then it works like an estate plan, and then it goes down to the beneficiaries. But the state doesn't count them against the senior, so they're able to qualify for things like Medi-Cal benefits, or if we're talking about a Veterans Asset Protection Trust, to get veterans pension benefits. Now, also, it's what we call an intentionally defective trust. In other words, we want to get the tax benefits of, for example, being able to sell our house and collect on our Section 121 exclusion. In other words, if you live in the house for 2 out of the last 5 years, you're not going to pay tax on the first $250,000 of gain, $500,000 of gain if you're a married couple. Similarly, if you're holding it in a trust and you pass away, under Internal Revenue Code 1014, we have a full step-up in tax basis on all of our capital assets. So in other words, the heirs can turn around the very next day and sell these things tax-free. You always hear about people doing things like 1031 exchanges on property and such because they don't want to pay the taxes. Well, if they just hold on to the property investments and they're holding it in a trust, they're going to get that 1014 step up in tax basis. That is maybe the only benefit that we get as an Americans to pass away in the United States, is our assets get this step up in tax basis, so we're able to sell them later on completely tax-free.
So I think, Randall, there are some of our listeners that lost you, a while ago.
Okay.
And the numbers and the laws and everything like that, and it's difficult, but there are certain rules and laws that people, all of us, have to follow, and they are beneficial to the families, the caregivers, and the patient, the person themselves. But to try to get a knack and understand these is not an easy chore, and getting good legal understanding of this is important. Now, I understand, I'm lucky because, in what you've said, I understand everything you've said, but I know that I had to get to that point to be able to understand it. I didn't always know all the numbers and the laws, but I understood what you were saying. Most people who don't understand this, it's a detriment to them. And if they don't start taking advantage of the wealth of information that you have, that's, to me, a big problem, especially for some of the people in Santa Clarita. Now, I know some of my patients have done this, what you're talking about. But I would say, now speaking of numbers and putting it out there, I would say less than 5% of my patients and their families know about all the important aspects of what needs to be done in the future to protect them and their families.
That totally comports with my understanding as well, because the majority of my business is redoing estate plans and turning them into elder law plans, which incorporates the estate planning, but also deals with all these elder law issues. And the problem is that people don't know what they don't know. And the information is complicated. It's out there, but unless they actually go see an elder law attorney and they get it deciphered, they're not going to understand it and understand why they need it.
Right.
That's very true.
It's so important that we do, that our listeners, despite, all the things you've been mentioning, and to be honest with you, I don't think it's been really legalese. And certainly you can try to look at some of these things up on the internet, but it doesn't work that way.
No, everybody's situation
is different. You really need to, it's like a patient's coming in and I've got chest pain. For me, that everybody's situation is different, and I have to get through all that information to figure out the direction I'm going to take them.
Absolutely correct. And that it's very similar to financial planning and medicine in that way. You have to go in, you have to talk to a professional about your particular facts and circumstances, have that professional apply the law or the medicine or whatever the case may be to your particular situation in order to make recommendations for you. Sometimes
that's very true, because, I've read different bits and pieces about which you've been talking on the internet. And I read it, and I'm thinking, wait a minute, what did I just read?
Yeah.
The written word doesn't explain to me what I just read.
Right.
And that is a big difference.
Yeah, with my clients,
reading.
I always try to break it down into plain English. And
Absolutely.
I say I'm leaving out 95% of the analysis here because I just want you to take away.
Get to the bottom line.
Yeah, I want you to understand what it is that we're getting at here. And it is really critical. Again, you've got to go, and you can't sit on your hands, especially, initial consultations at our office, they're free, they're complimentary. So people have nothing to lose by coming in and discussing their situation.
And I think on that note, we need to take a break, and we'll be back in a few minutes to speak with you more on this subject.
Sounds great.
I'm Barbara Cochran with my co-host, Dr. Jean Dorio, on your hometown station, AM 1220 KHTS. Welcome back to the Senior Hour. I'm Barbara Cochran with my co-host, Dr. Jean Dorio, on your hometown station, AM 1220 KHTS. And we're speaking with Randall Kaiden, who is an elder law care attorney.
Right, exactly.
Yes.
And, one of the things that, we were talking
Elder
about
law
the
care
attorney,
attorney.
But a lot of the people that, we're
I've
mentioning
caught that.
all these different terms, but a lot of the people we talked about healthcare directives, financial power of attorney, and estate plans, a lot of people who are listening don't have any of that, or at least not all of it. And then the second thing is many of them who don't revisit them. And both of those topics are keen and important for our seniors and their loved ones to be concerned about, because there's so much legalese with this, Randall, in terms of trying to figure out what the best direction to go. I deal with medicine and the medical part of it, and to me, medicine technology moves forward, but it's not like with you and the law changing, and you have to sometimes take a whole U-turn in terms of how you're going to recommend certain things to your clients.
Absolutely correct. It's, again, it just comes back to the theme that you just can't be complacent about this stuff. You gotta periodically look at it. With our healthcare directives, we create HIPAA authorizations because we have the HIPAA laws. We also have final instructions on how you want to be buried or cremated or what happens after you're gone, autopsy, whether you want organs donated or not. People have a lot of thoughts on this. And the medical landscape and the technology is changing so quickly. And what you might have thought that you wanted to happen, you're no longer living in that world. We're living in a different world. And Doctor, you brought up a great point during the commercial about, really where the rubber meets the road is when you're actually tested. These things come up, and we have all sorts of bizarre scenarios that come up. And this is not even talking about when families start to fight, like in the Terry Schiavo situation, or we had the Cruzan case. We had different cases that went up to the Supreme Court, and people...
Communication.
Communication is key.
That is the key.
It's key, but there's a fallacy in the communication. And the fallacy is that you can outline every possible scenario that might happen to you medically, which you cannot possibly do. And in fact, things change so often that what you thought 10 years ago no longer applies.
Plus, there's an economic vantage point that hospitals and some of the insurance companies see in using medical futility against the patients who might come into our hospital ill in an ICU setting, but because of interpretation of a advanced directive made 20 years ago, they will interpret it, a 20-year-old document, when it hasn't been revisited, to the detriment.
That's right.
Of the patient, and even to legally overwhelm anybody who might be designated as power of attorney.
And actually a couple of months ago, I had a client in his 60s. He was the agent for his mother. This client happened to be a doctor, and he called me sobbing on the telephone because the doctors at the hospital were telling him that his mother shouldn't be receiving a certain kind of treatment, and in his opinion, she should be receiving the treatment, and he was the power of attorney, and we had a lot of trouble. We were thankfully successful in getting the doctors and hospital to implement what it is that he wanted. He was the advocate for her, but can you just imagine, this power of the doctor himself, he had a power of attorney for his mother. He understood the medical background, and he disagreed with the doctors. But the doctors in hospital, I think they were looking at the bottom line, the way you were putting at it, and they said, this is medically futile. We're not going to do this. And so there was a little bit of a war started. What does that mean? What is medical futility and the ability to dictate what kind of treatment you should be getting for whatever malady befalls you?
And unfortunately, I think some people are forced into a situation of medical decision-making that they don't want to go into. And it's not just ignorance. It's the fact that they're being overwhelmed by a system that says we're looking at bottom line now. And, I wrote an article not long ago about life expectancy in the United States, that it has slowly increased and increased and increased. And I got a lot of notoriety because I said in my article that it is going to decrease now because of the claim of medical futility by some of the hospitals using it against patients and cutting them off from care. So I think that we're seeing a lot of that right now. But despite that point, you still have to get all your ducks lined up.
That's
Randall.
right.
And in order to do that, I'll tell you, you have a whole wealth of information, for our listeners out there, and I think they should honestly take advantage of what you know and how you can apply it to their care.
Yeah, and just like in the medical field, we're seeing the same thing in the financial field. You have big banks like Bank of America or Chase, and they come and the agent comes in and they want to do something for mom or dad, and the banks are giving them problems. Now, we could sue the banks, and we know we're going to win, but why do we want to go through that kind of hassle?
Oh, no.
Right.
And it's crazy. It's insanity. So, but if again, they plan ahead and they go in and they make sure that those powers of attorney are accepted and they assign whatever documents at their banks in advance, then they're not going to have that issue. Same thing with the trust. Again, so the advanced planning, you can eliminate a lot of the negative issues and take advantage of positive things that can help you.
So Randall Kaiden, if our listeners want to get a hold of you, quickly give us your phone number.
It's 661-247-8433.
Great. That's 247-8433. Randall, thanks for being on the show today. Happy Thanksgiving.
Thank you for having me.
Happy Thanksgiving to all our listeners. We are sponsored by Advanced Audiology and Comfort Keepers in Home Care. Listen to us next week on the Senior Hour. Now go and enhance your quality of life.